Did you know that you might be able to use a witness's immigration status against them in court? It's a fair question, and we're going to talk about that today. In other words, I've talked a lot about using immigration on the defensive side. Now I'm going to talk about using immigration information on the offensive side. Now, in other videos, we've talked at length about how immigration and criminal law kind of blend to each other. I spoke a lot earlier about how when I'm representing or defending a non-citizen criminal client, not only do I always want to make sure that I can get the overall penalties down as much as possible, but I also want to make sure that whatever result I get in criminal court is compatible with my client's needs in the immigration realm. Is it going to upset their application for status? Is it going to jeopardize their ability to stay in the country? These are things called collateral consequences we're on the lookout for. But what if my client tells me that the witnesses against them are themselves not citizens? And maybe this plays into the defense theory in the case. Well, every person fighting a criminal case has the right under the Sixth Amendment to confront and cross-examine their accusers. The Supreme Court has elaborated on this right in a case called Alaska versus Davis, where a person was on trial for a criminal offense. They found out that one of the witnesses against them was on some type of probation, and the court ruled that they couldn't probe into the person's probation status when they were on the stand. The defendant was upset about this. He wanted to show that the witness might have had what they called motive to curry favor with the government because they were being supervised. They had a motive to provide prosecution favorable testimony and therefore maybe even lie against the defendant in order to help the prosecutor secure a conviction and then maybe help the witness out in terms of getting them through probation or not pursuing a violation against them. Supreme Court ruled it was improper to stop the defendant from questioning the witness against this issue. Now, what does this have to do with the immigration issue we have today? Well, some witnesses against my client may have a similar motive to curry favor depending on their immigration status. Maybe perhaps they've been recently ordered deported and perhaps their status as a witness in a criminal case against my client is a springboard to them getting some type of immigration status. People might talk about something called a U visa, where you or a family member are allegedly victims of a crime. The feds might approve a type of visa for them so that they can, remain in the country, participate in the case. There's many good reasons for that, and I'm not going to debate the wisdom of that policy, but the reality of it is this. If the witness against you needs some badly needed governmental benefit and it's contingent on them, or at least in any way related to offering testimony against my client, that is probably something that I'd want to probe into when I'm defending my client in their case. So where does this sit with the law? We get to the California Evidence Code. California Evidence Code section 351.4 places a lot of limits on the court's ability to discuss and disclose a witness or a party's immigration status in open court. And this makes sense because, after all, we live in one of the most diverse states in the country. I mean, it's great that we have many people here who weren't originally born here, and our population goes greater and more diverse every day. And many hardworking people want to lay roots in this country, and they don't want to have the burden of being embarrassed in court or shamed for not being a citizen, or have their immigration status revealed for fear that maybe federal authorities might come after them. These are reasonable fears. At the same time, this has to be balanced against the needs and rights of a criminal defendant who's trying to maybe prove their innocence and show, hey, this might be a reason why these people are lying against me. They're lying against me because they have some sort of incentive, some clear motive to get an immigration benefit if they cooperate with the government against me. These things are intertwined, and that's part of the story about why I'm innocent. So California Evidence Code 351.4 tries to strike a balance between these two very important needs: the right of the accused to confront or cross-examine their accusers, and the rights and needs of many hardworking people who want to be able to remain in this country without having their immigration status talked about so openly in official proceedings. California Evidence Code section 351.4 states that a person's immigration status is not supposed to be discussed openly in a criminal court unless either one, the party just consents and is okay with that being discussed, or two, the court is satisfied after review of the information and the evidence that it is actually relevant to the criminal proceeding and that its relevance to the criminal proceeding is not outweighed by other important risks like waste of time or undue consumption of resources or confusion for the jury. And some cases have ruled on this issue. Do you have a case where, for example, you're caught on surveillance beating somebody up, and it turns out that that person was in the middle of applying for a U visa related to this case? That's technically relevant, but some courts might not let that in because there's already so much other information connecting you to the crime. Maybe you're better off attacking the reliability of the video surveillance, for example. Also, when did the person actually apply for the immigration benefit? If the person didn't even know about that immigration benefit at the time they first spoke to the police, and then only later on started getting it when they're testifying at trial, the trial judge might not feel inclined to let that in. Everything's different, of course, but in that situation, the motive to lie, the motive to falsely report on the defendant doesn't really make as much sense when they're already reporting on the case before they even know that they could get a visa or some type of immigration benefit. Now, let's say hypothetically, at the time of the witness reporting to the police against you, they're already in desperate need of some sort of immigration benefit, and they end up getting it very soon while they're actively testifying against you in the initial stage of the proceeding. In that situation, the trial judge might be more inclined to let that information in because it shows they may be more actively or motivated to testify against you and maybe therefore testifying against you for an improper purpose. Anytime you're defending a case, the issues of witness credibility are always an issue. You and your lawyer should always strategize very carefully. If people are saying you did something wrong, how do you attack their credibility? And sometimes, one of the issues is, are they potentially trying to get some sort of benefit from the government, like an immigration benefit? If you are fighting a case where you think that the witnesses against you are trying to maybe scheme themselves into an immigration benefit improperly, talk to your lawyer about Evidence Code Section 351.4 and whether you can get into this theory in court. Thanks, and stay safe out there.